Begin.
Good evening. We are here for the last class of real estate principles.
Woo!
All right, Mr. Eugene, don't get too ecstatic. Calm down. Stop crying. We're okay. So,
I have a heart attack over here.
I know y'all, those of you in the online world, he's crying over there. Stephanie, can you give him some tissues back there? He's going to need them. So, but no. We're going to go ahead and we're going to talk about closing the real estate transaction. Okay. So we actually had this a little earlier. We just had this just a minute ago. So we're going to repeat it. Okay. Learning objectives. We're going to identify the documents required from the buyer and the seller as a real estate transaction closes. We're also going to describe the provisions of RESPA, Regulation Z, and P53 of the TDI that relate to closing transactions. So we're going to talk about the purpose, the covered transactions, the major provisions, forms required. We're also going to talk about Regulation Z of the Truth in Lending and the Texas Department of Insurance. We'll further identify at least 6 types of expenses that are incurred by the buyer and or seller at closing, and who's going to pay for each one, as well as distinguishing between what's called prepaid and accrued expenses, as well as statutory and calendar day prorations, and further compute the common prorations referencing the debit and credit distributions. So, there are some lists of things that need to occur when dealing with a pre-closing procedure. Now, if you notice, when we're teaching tonight, we're going to be talking about both sides. So on the left-hand side on this one, we're talking about the sellers, while on the right-hand side, we're talking about the buyers. So the issues that the seller needs to be aware of is if you're representing the seller's or the seller, you need to make certain that buyer has the financing. And we ran into that issue, okay? You may have everything done on your end. Travis, you may have everything ready on yours. You've done it all, got it all together. Boom, you're ready to go. However, Miss Linda didn't get financing.
Come on, Linda.
Yep.
What did I do wrong?
Miss Linda failed to get financing, and since she failed to get financing, the buyer isn't going to be able to close, okay? So the seller needs to make certain that the buyer actually has financing. Now, for them to get financing, is it as easy as just calling them, Travis, and saying, hey, Linda, you got financing? Yeah, okay, good. Is it that easy?
That'd be nice, but no.
No. You got to call, and you got to make certain that Miss Linda has gotten the appraisal. Make sure that Miss Linda, if they ordered a new survey, Miss Linda's got a new survey. You got to make certain that all of those things are done before the lender will even issue the closing, the right to go ahead and close, okay? Further, the seller has to make certain that after the inspections, that whatever inspection issues there were, and the seller agreed to repair, the seller repaired those issues, okay? And one of the key things on this one is, Stephanie, if you're representing Mr. Eugene in a transaction and he's selling his property, and Mr. Travis has gone with Miss Linda, his client, Miss Linda, has asked that Mr. Eugene goes in and replaces some things in the electrical box or the panel box and the roof. He wants some things fixed up there. You got to make certain that Mr. Eugene actually gets a professional to do it. Mr. Eugene can't just go do it himself, okay? Unless it's minor stuff, okay? If it's minor things, Mr. Eugene can do it. There was one I remember that I was getting ready for a closing. And again, what's the thing you do before? If you're representing the buyer, Miss Linda, what should the agent do with the buyer before going to closing the next day? What's that called? The final what?
Walkthrough.
Final walkthrough. So I had one that I had done, went to a final walkthrough, and there was a opening in the panel box. Now, Mr. Eugene, what if a breaker's been taken out but the opening's not closed? Is there any problems with that?
Yeah.
What's the problem? You touch it and you jump around and do a dance.
Yeah.
What's that mean?
Shock you.
It's called, it can kill you, actually. If you touch the right thing, it can kill you. So the inspector noted that as deficient. So the inspector put deficient on it, And so the buyer just wanted the seller to just put a plate in there, so it blocks it like it's supposed to. Well, they said they would do it. Go to our final walkthrough, and guess what? They put duct tape over it. We said, thankfully, proper plate covering. Okay, duct tape is not proper plate covering. Okay, so again, just because your client, and Travis, you know this yourself, your client may tell you that they've done something, and you're like, okay, well, they've done that. What I learned in my life is get pictures. Because had I asked the seller's agent for pictures, we would have seen, well, before the final walkthrough, that they had put duct tape on it. And we would have said no. Okay? It has to end up, it's got to actually be what is said. Now, had I just said in the amendment, seller to cover the panel box or cover the spot in the panel box, well, Mr. Eugene, did you technically cover the deal in the electrical box?
Sure did.
You sure did.
You specify.
That's right. So you got to specify what you want. Now again, on the buyer side, now the buyer has to deal with any title evidence, the seller's deed, as well as the removal of any liens or encumbrances, survey, inspection reports, and leases. They have a lot of things that the buyer's got to deal with. Why? Because they're assuming the new house. They're getting a brand new house, so they're assuming all of this stuff. So they got to make certain that they have each and every one of these items taken care of. Now, at closing can be one of two ways, okay? Closing can end up being, before we jump on this slide, closing can be one of two things. Closing can be where we sit down at the table, okay? So you're the closer, Mr. Grossman, and I'm the buyer. I can physically come to you and I can sit down at a table and I sign papers in front of Stephanie at the title company, okay? And sometimes, Miss Linda, if I'm selling and you're buying, sometimes Stephen might actually have me and you at the closing table at the same time. But is it always going to be like that, Travis? No, because a lot of times what happens? Well, think about this. Think about a nasty transaction. Think about your worst transaction you've ever worked. Imagine putting the buyer and seller in a room together. How would that go?
That's not good. I can think of one. That would have been pretty bad.
Uh-huh. Put buyer and seller in the room together at a closing. You'd be playing, basically, you'd be having to help referee, and
I wouldn't be in that room.
you wouldn't be in that room.
I wouldn't want
Because of COVID. Because of COVID.
Because of COVID, right?
Yeah, I don't wait in the car. I'll be out here, guys.
Maybe no one saw it.
Yeah.
Yeah.
There was one actually that we had dealt with that I actually, my agent did not tell me. Thankfully, well, it wasn't a good, pretty big issue, but my agent didn't tell me that she had scheduled closing a day prior. We had it on the next day. She had it the day prior. They'd moved it back. Well, she got up that morning and she was sick, couldn't make closing. So she just told her client, well, you just go on down there and, sign, and that's it. I'll let you go. You're just going to go in, you're going to sign, you're going to leave. No big deal. I didn't know anything about it. Well, guess who happened to show up at the exact same time that the seller was showing up? The buyer. And the buyer was furious at the seller.
Yep.
So the seller and the buyer sit down in the room. They got in a little spat. And the seller got up and walked out. Said, screw y'all, I'm out of here. I ain't signing, you know what? And walked out. So in that situation he walked out. I didn't know nothing about it until I get a phone call from my agent going, yeah, deal didn't go through. Seller refuses to sign. What are we going to do? I said, what are you talking about? That closes tomorrow. No, we closed it today. What? Where were you to referee it? I was sick.
Why didn't you tell us?
Why weren't we involved in these things? Okay? But what comes down into these situations, as I tell people this all the time, is you never not want to go to your closing. If you can't make your closing, you always want to have somebody else with you or somebody cover for you. Even if that person is basically someone that's never even dealt with the person. You just need somebody there to kind of do what? Referee it. So had the title company, had somebody been there and they walked up and said, you know, I'm here with Stefan to close, they would say, well, we can put you all in the same room. That person could have done what?
Nope.
No, we're not going to do that. Okay? Because Stefan, if he went by himself, he has no idea.
Yeah.
So he's just going to do what the title company says. He's just following. Somebody's got to be there to say, separate room, or let's wait an hour.
Can
Okay.
you send another agent from a different firm or a friend of the family to sit in your place?
No, unless broker agrees.
Curious.
Broker can't. It cannot be somebody else from a different company or anything just because of liability purposes. It has to. Now, if the broker agrees to it, and the broker says, "Sure, no big deal," it's up to the broker on that one. But most of the time most brokers don't want to do that simply because they'd rather have somebody from their office. And just because of the fact is there's too much liability, not only for the broker that it's closing, but also for the other broker. If something goes wrong, there's an issue there. Okay. So you always, and it just comes back to, Ms. Linda, as you know, we've talked about this, communication. That's what it comes down to, just communication. Again, like I said, it can be face-to-face. It can be closing in escrow, where the seller will deposit the deed, the title evidence, payoff letter, etc. And the buyer, of course, will deposit the cash balance, loan documents, insurance policy, and survey. And then there's basically the doctrine of relation back. Further, we also, as we've talked about in one of our trainings today, the good funds rule also applies. Okay, and what that basically means in regards to the good funds rule right here is anything that is going to end up being over 1,500 or over, just like we had our training on Monday. If the amount is under, if you actually put Travis on a contract for earnest money, that they're going to pay $1,499.99, then you're pretty much good. Okay, but the minute you put $1,500, the good fund rules kick in, and you got to wait up to 10 days for it to clear their bank. Okay, so in that particular situation is sometimes that can be problematic. Okay, so a lot of times, now if you try to explain this to your client, it says, yeah, let's do earnest money at $1,499.99. Your client's going to be like, why can't I just make it $1,500? Well, because of the fact I'm trying not to influence or put the good funds rule into play. I'm trying to avoid it. But again, these are things you need to be aware of. Now, RESPA is also administered by the CFPB, okay? And it's to protect consumers from what's called abusive lending practices, all right? It's the disclosure of the lender of all costs associated with the closing, and it has to eliminate kickbacks and unearned referral fees. Now, what I'm saying in this particular situation is years ago, Mr. Eugene, you may go to a closing table, and you sit down at your closing table, and you finally see the numbers now in front of you while you're at the closing table, and they're like, oh, well, we had this fee and that fee and this fee and that fee and this fee and this fee and that fee and this fee and this recording fee and this one and the Travis fee, $500,000, and so all these different fees in here, and so you're selling your house for $140, and so now you get $5. Now, it wasn't that crazy, but that's how it was to a client. Okay, if a client loses 1 penny, what do, Travis?
Freak out.
They got freak out. We want the whole thing overturned. Okay, because 1 penny. So the thing is you want to make certain that you understand that it protects the consumers from the abusive lending practices. Okay, and again, they have to disclose any and all costs, but also eliminate any kickbacks. Because what used to happen was, you know, I rub your elbow, or you scratch my back, I scratch your back, things of that nature. You know, we move all this money around, so I put more money in my. Nope, can't do that anymore. RESPA does not allow that. Disclosures are also required on all first liens, residential, federally related mortgage loans, with a few exceptions, plus home equity, home improvement, refinancing, and reverse mortgages. Okay, so any of these types of loans, RESPA applies to. But in some of these situations, if it doesn't apply to it, then can you have kickbacks? Yeah, because this only applies to these types of loans. Okay, So again, RESPA applies to loans that made by the lenders with deposits insured by a federal agency, FHA and VA loans, and loans administered by HUD, loans to be sold to Fannie, Freddie, and Ginnie. Okay. However, RESPA does not apply to loans on property with 25 acres or more. So if you're buying more than 25 acres or 25 acres itself, RESPA doesn't apply. Okay. If it is a business, commercial, or agricultural loan, don't apply. If there is temporary construction or vacant land, doesn't apply. Assumption without a lender approval, does not apply. Conversion of loans to new terms, does not apply. And sell to secondary market, does not apply. Okay, so you can have in these some kickbacks or things to that nature, but it has to only be the ones that we have stipulated here. Okay. Now, RESPA requirements in regards to the TREID rule, basically these are disclosures at the loan application, and they're not later than the 3rd day after receiving a loan application. Your client must, at the time that they apply, from the 3rd day of receiving the application, they have to get the home loan toolkit, which is a step-by-step guide, and a loan estimate. I'm going to tell you something. For those of you that are going to be a real estate agent, we had this issue happen the other day. Okay, you cannot do this. Say, Mr. Eugene, that you go over and you refer your client Stephen to Mr. Keith. Okay, so you tell Mr. Grossman, hey, Stephen, you go talk to Keith. He is my lender, my go-to lender, and he'll take care of it. So Stephen goes and he fills out the stuff and he sends it to Keith. Okay, so now you go over and you say, well, I'm done. Woohoo! I just wait till Keith calls me. So I'm going to sit over here. I'm going to sit down here on my little stool and I'm just going to twiddle my thumbs. Keith will call me sooner or later. Well, man, have y'all noticed that it's closing tomorrow? I haven't heard from Keith. Well, I might need to call Keith and see what's going on. Hello, Keith, you there? Yeah, did you go over, you got Stephen all taken care of, right? Everything's good, right? And then Keith goes, well, man, I've been out on vacation for the last week. Well, oh, yeah, that's fine, but Keith, you took care of Stephen, right? We're good to close, right? I haven't even done nothing, Eugene, not one thing. Yep. Who dropped the ball on that one? Who technically dropped the ball? Keith. Keith dropped it, right? But in a court's eyes, who exactly are you representing, Mr. Eugene? You're representing Stephen. And had this been your transaction, would you have just sat over here in a corner and just twiddled your thumbs and I'm just going to wait until they call me? Was that what you'd do with your loan? No, what would you have been doing? You'd be calling Keith what?
Man, what's
Every
going on?
day,
How
right?
you doing? What's going on? Now, I know it's day 2, but I don't know.
Yeah. You've been calling him exactly the same way if it was yours. So why aren't you doing that for your client? So while Keith dropped the ball, the court's going to come back and say, because remember, a court always goes back to the root of the problem. So they go back to the root and they'll say, had this issue, where did this issue occur? Well, it occurred by who? Mr. Eugene referred Stephen to who? To Keith. Had Mr. Eugene not referred Stephen to Keith, would there have been an issue? No. So who's at fault here?
I guess Eugene is.
Eugene is in that situation.
Uh-oh.
Now, Miss Linda, let me ask you this question. What happens if Mr. Eugene now, Miss Linda, said to Stephen, well, I've got 3 lenders. I got Mr. Keith, I got Travis, and I got Linda. Take a pick of who you would like to call, or you can call any other person that you would like to call. And then Stephen went and used Leela, who wasn't even on Eugene's list, and Leela dropped the ball. Now, who's at fault? Leela's the one that dropped the ball.
But he's one.
But can he come back and blame Mr. Eugene?
Not really.
Not really, because of the fact of the matter is, he was given 3 recommendations. He ignored them, went and got his own. So now let me ask this now, Mr. Eugene. Since he goes and hires Miss Leela to use, does that mean you just don't deal with Miss Leela and you just let him deal with it all?
No, I still got to do it.
You still need to be calling Leela, following up. Just because he doesn't use one of your 3 does not mean you just get to ignore it.
Sure.
Okay? You still got to stay on top of that person. But what happens is if Miss Leela doesn't respond to you, then you can tell Stephanie, I've been trying to get over to her and she won't talk to me. So you need to call Miss Leela to give me authorization so I can talk to her. Because some of these lenders will not, if you don't have rapport, they won't talk to you because it's your personal information. And they don't know, Mr. Eugene, that you are representing him. Okay? So you can't simply in this situation just ignore the lender. Just like the title company. Say, for example, that you told Stephen, here are 3 title companies, Travis, Linda, and Justin, and he goes and decides he's going to use University Title. He don't want to use us 3. Doesn't mean that since you didn't get your way, that you just say, well, I'm going to sit over here in the corner and pout. You can't do that. You have to work with who your client chooses. Because otherwise, if he chooses yours and crap goes bad, you're liable. Okay? So very, very important here. Now, there are 3 days, of course, in regards before the consummation. It's basically the closing. The key thing back here is 3 days prior to the loan application, you have to get these documents. 3 days before the closing, you have to get your closing disclosure and your affiliate business arrangement disclosure. Now, what this means here on this nice little chart is that in this situation, the previous one where we talked about the LE, which is the loan estimate, must end up being very close to the closing disclosure. Now, Travis, let me ask you this question. So you're representing Miss Linda. She's buying a house, okay? And they end up, you got closing tomorrow, and she just got her CD today, her closing disclosure today. So you're closing tomorrow? Why not?
It's not been 3 days before.
That's right. So if your client gets the thing, if Miss Nobles gets it today, and it's on the contract that you're closing tomorrow, guess what? You're not closing. So do you see why it's another reason you need to be calling the lender? Because if the lender has yet to get, if it's a week before closing, you better be calling that lender every day and finding out, when am I going to get a CD? When am I going to get a CD? And some agents end up, they don't want to call because they feel like they're a squeaky wheel.
You need to be sometime.
Why did you say that, Mr. Eugene? Why you say that's why you need to be sometime?
Because if you don't, then you run into things like lawsuits and everything else. You get your job done.
That's right. That's one thing that my dad always taught me. Sometimes you got to be the squeaky wheel. Because of the fact of the matter is if you're the one that's constantly calling, huh?
It's the only way you know things are wrong. You gotta speak.
That's right. You call and you call and you call and you call. What are they eventually going to do, Miss Linda? If you, and I'll tell you this for here. If Miss Linda, if Travis, you need a form for Miss Linda, and you call her at 8, you call her at 9, you call her at 10, you call her at 11, do you think Miss Linda's going to get you that form?
Either that or I'm gonna hear the doo-doo-doo. This phone is
Yeah.
disconnected.
Yeah. She's going to get it to you, right?
Oh, most likely.
One of the ways, because Miss Linda, why are you going to get it to him if he's calling you every hour on the hour?
If she wants me to shut up.
Are you? That's right. That's right. That's the key thing. You know, sometimes you've got to be that way because otherwise they know there's an issue, and Stephanie can vouch for this. They know there's an issue and they're trying to avoid you. And if you call and 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 they don't answer, guess what? What's that tell you normally, Stephanie? If you call me and we're supposed to close tomorrow and you call me at 8 and I don't answer, you call me at 9 and I don't answer, at 10 and I don't answer, what are you starting to think?
You're avoiding me?
I'm avoiding it. Do you think there's a problem?
You screwed up.
Probably. And so should that mean you just stop calling me?
No.
No, you need to what?
That's what
Keep
you
blowing
said.
my phone up or go to my office, right?
Hunt him down.
That's right.
You call, you text, you email.
That's,
Dog the bounty hunter.
there you
That's
go.
right.
You call. Because again, the thing is that the key thing of all this, I tell people this all the time. If you truthfully, during the option period, if you work your butt off for the first 7 days of when you go under contract and you get the survey done, you get the appraisal, or not the appraisal, but the survey, and you get any inspections done, you get repairs done, you get all the stuff that needs to be done, and the only thing that's left is the appraisal, you've knocked everything out. So truthfully, you could do what? You could chill until the appraisal, but what you could do instead of having to work every day for 8 hours a day, you can maybe call every other day until the appraisal gets in. Then once the appraisal gets in, then you can negotiate if you need to negotiate. And then after that, there's really nothing else you need to focus on other than who? The lender. Because they're the last one that gets the CD.
What if you have a warranty? You have to make sure you get
Well,
the
you have to
warranty
order
too.
your warranty, but what I'm saying is you could have done all that during the 7-day option period.
Well, it's true. But
See, when I normally do, when I get out there and I do things and I get a transaction, I get my form and I go through and I write down my dates on my calendar. I got this. If I got a home warranty, the day everybody signs that I've received that contract, I order a home warranty right then, that same day. Because if the transaction falls through, is the warranty still going to be ordered? So there's nothing that happens, and they're just going to wipe the file. So I just knock everything out in the very beginning, and so when it's all said and done, I'm finished, and then I'm able to sit over here and twiddle my thumbs for a little bit, okay, and then turn around, and I can knock out the other ones. The worst case that you want to do is wait to the very end, okay? Now, in regards to disclosures at closing, the corrected closing disclosure, if the APR is going to be more than 1/8%, did you see that again? 1/8%, okay? 1/8% in this situation, they need to be added prepayment penalty or any types of changes to the loans. They need to be closed no sooner than 3 days after the new disclosure. So in that particular situation is guess what happens? If you got to change the CD form, and Mr. Eugene, just 1/8%, how much is that?
Very little.
Very tiny, maybe a few cents, a few pennies. If there's any change to the CD, guess what happens to that 3 days? Restarts. So if Mr. Eugene, you get your CD form today, when could you technically close if you got it today?
3 days from today.
3 days from today. Well, you get it and you don't review it until tomorrow, and you notice that, oh, there's a problem. This changed. They have to change it now and re-get it to you, and they reissue it to you on Saturday. What happens?
Can't close
Gotta close 3 days later.
Yep.
Okay. So, also, if the fee in the CD, the closing disclosure, exceeds the estimate of fee in the loan estimate beyond tolerance level, then the refund to the borrower, which is going to be in excess within 60 days of closing. Okay. These are things that need to be disclosed. The initial escrow statement is going to itemize the estimated charges to be paid from escrow in the first year. Of course, the things that are going to be itemized are, of course, going to be your taxes, insurance premiums, homeowner dues, and mortgage insurance. This also lists the amount to be placed in escrow with any cushion. Now, I want to tell y'all all this because I think that y'all need to hear this. And Miss Leela, you might want to hold on into your chair because this happened over in Houston area. So here we go. I'm gonna, Mr. Travis, come on up here real quick and tell them about your brother who ended up. Tell them kind of what happened with your brother. Y'all, what all you represented him. You went to closing. Tell them what you just found out recently.
Yeah, so my brother bought a house in, I guess it was August 31st was our closing date. So he bought it last August. I got a call from him, let's see, when was that? Probably last week at some point. It was like last week when he first called me, or I guess 2 days ago at least. And he said that he just found out that his house has $5,000 in back taxes on it. So he at first looked at the wrong address and told me $32,000. So that was a bit of a shock. But basically, title is supposed to catch all that because they'll contact any sort of worries, any taxes, anything like that that's owed on the property, and that'll all come out at closing. They'll kind of level all that out. So if the seller owns taxes, he'll either have to pay those taxes off before he can sell the house, or in the closing, he'll get compensated. Like he'll send the money he gets from the closing over to the government, all that sort of stuff. So either way, it always gets settled at closing. Title companies are not allowed to sell a house with taxes on it or anything like that charged to it. Homeowners dues, mortgage insurance, all that sort of stuff. My brother Tyler called me and said that he has $5,000 in back taxes owed on it. So the good thing about that is there is title insurance, so he gets to call or I get to call title and have title basically do their own investigation and figure that all out for themselves. So he doesn't have anything to worry about. But that is kind of a problem that you'll get, is that, you know, title did not catch that on their disclosure, so, or any of their research beforehand. So that's something that we have to do now, even though it's been 6 months or whatever since he actually closed on the property. So
See, good points there. So the key thing that comes into this situation is like we were saying, you know, you got to be careful, because like we had earlier today, we had a title company come in and talk to the agents and all. And one of the things that they said is, you know, sometimes the tax office may send that the taxes are good. There are no back taxes. And they may send a clear tax certificate that it's just no issues. And if the tax office does that, then while the title is still responsible, they're going to go back to the title or the tax office and say, what? Y'all issued us a letter that said it's good and it's not. You need to figure this out. Okay? But the only thing is, in this situation, is remember we talked about in taxes, especially property taxes, the whole go of property taxes is that they can force the sale of the property to get paid. Well, in that situation is, what if the person no longer owns the property? How are they going to force the sale of something that that person was supposed to have already been cleared out? So in that situation is, that's when title needs to come in and they get to get their lawyers and all that and figure all that stuff out. But yes, you may run into some issues like this, and you need to be aware of them, okay? In regards to Texas title insurance disclosures, there are title insurance premiums that must be paid. Now, let me explain something. People always ask me every time, they say, well, how do you pick a title company? Well, Miss Linda, how do you pick a title company? They all charge different fees, right?
No, not normally, they're about the same.
They're all the same.
Mm-hmm.
All fees are going to be the same. So it does not matter in regards to if you want to use Travis's title company or Eugene's or mine or Stefan's. What does it ultimately come down to? Service or preference. Okay? If you have a good service, good rapport, you're going to have business. If you go to Mr. Eugene's every time and he screws up every single transaction, how long is he going to be in business? Not at all.
Word of mouth can destroy you.
That's right. So in that situation is, you've got to make certain by all means that you understand that there are going to be premiums, but oftentimes when they pick a title company, the title company is basically picked by, like Stefan said, either preference or based upon them just having rapport or good service. Okay. Again, they're also going to itemize fees and charges paid to the closing agent that are combined on the closing disclosure. Payments to third parties of any part of the title insurance premiums are also going to be made. Sometimes, thankfully, I have good rapport with my people. I can have an inspection done, and my people don't pay nothing at inspections. So what happens is, Mr. Eugene, Miss Linda, y'all want to go out and buy a house, we can do inspections, but you don't have to pay my guy at all. He just bills you to closing. But if some inspectors, they want payment up front the day they get service. And that's because the fact is if Stefan orders one in Dallas, they don't know Stefan from anybody. So in that situation is, they want to make certain they get their money up front, because if the deal falls through, are they going to have any chance to get their money? No. Okay. So again, this is where basically during the itemization, they're going to break down the fees of everything: closing fees, the realtor fees, inspector, sometimes appraisal, A lot of different things that come into play, but they're all going to be broke down in these situations. Again, the disclosures in regards to after closing is going to be the annual escrow statement, the servicing transfer statement, which is approximately 15 days before the loan transfers by the current servicer, and 30 days after the loan transfer with the new servicer. And Texas laws, basically the statement regarding complaints are also going to be provided. Now, let me say something on this one. When I'm trying to think, I think it was Eugene. When we were working on getting your payoff statement. And we tried to get the payoff statement from his bank, and he had the form. I think he had the monthly note that showed the payoff or the amount due. And he called him, and how many days they tell you that they could get that payoff statement to you? In Navasota, on the house in Navasota.
When could it get?
Yeah, wasn't it? You had all the documents and all. You just needed just the one deal that showed the payoff. How many days did they tell you it take them to get the payoff statement? Even though it was on the deal.
About a week, wasn't it?
No, it was 15 days.
15
20 days. And he already had the form that showed the payoff, but they couldn't use the mortgage statement or the note statement. They had to actually have a letter from the bank that said, this is the deal. Okay. And they said, well, it's going to take us 15 days to draft that. Well, that's kind of problematic. Okay. So in that situation, those are some things you need to be aware of. There are also, again, we talk about prohibitions and restrictions. Again, kickbacks or unearned referral fees cannot be allowed. Selection of the title company, as well as the limits on the T&I escrow, the computerized loan origination, and the controlled business arrangements. These are all things that cannot happen. Okay. So, for example, if Eugene, you're representing Miss Leela and she's selling her property, she cannot say, I'm not selling my house, I'm picking the title company. I pick the title. The only way that can happen is if the buyer agrees. She cannot dictate that I have to use this one. Remember, it is all an agreement. It cannot be dictated. And oftentimes, when somebody tries to dictate something, it means what? They most likely have a what? A kickback or a referral fee, and that's why. Okay? And I've had that happen before where they sent me, after it was all done, they sent me a business affiliation form stating that they wanted to close here because they were basically, it wasn't money or something, but they just had to give it and say that there was an affiliation. Well, of course it is, because the fact is they might own the title company. Okay? So again, you have to watch out for those. Now, in regards to TREC, in regards to rebates, the license holder is prohibited from contracting with a service provider such as a home warranty company if it would prevent or prohibit the license holder from offering similar services on behalf of a competing service provider. Okay, and one of these things that I can say, and well, let's go ahead and read the next one. It also prohibits the license holder from the acceptance of a fee for service provider if the payment is basically contingent on a party's purchasing a contract home warranty from the provider. What this basically states in this situation is that you cannot, for example, Miss Linda, you cannot be getting any type of compensation from a home warranty company. So say, for example, that your husband, Mr. Eugene, starts a home warranty company, and you want to end up, you decide, I'm going to require all my clients have to purchase Eugene's home warranty. Okay, that's going to be a requirement. It is actually prohibited by TREC, and if TREC finds out, you can lose your license. Okay, you cannot force somebody to use a home warranty company. It's against the law. You have to also, if you are getting any fees, any kickbacks from this, it can also not only jeopardize your license, but also jeopardize the loan, because the loans are regulated by RESPA, and it could actually cause issues with the loan overall. Okay. Also, payments received from a service provider for non-transaction related services. So you can get payments from a service provider for transaction related services. So after Mr. Eugene, Miss Linda closes Travis's transaction, he buys a house. and then you go over and you pay Miss Linda something for a non-translated or transaction-related service, that's legal. But you cannot directly or indirectly pay Miss Linda a kickback on anything in regards to a home warranty. A lot of times people think, well, I got my real estate license, so I'm going to start a home warranty company. And then I'll just make everybody end up pay me, or I'll make them use my home warranty and I'll make money off of it both ways. I'll double dip. Well, if Trek finds out about that, don't be surprised if you don't get in a lot of trouble. Okay, possibly lose your license. It also, what's called P53 of the Texas Department of Insurance, promotional or educational activities of title company personnel cannot be conditioned on the referral of the title companies. Used to a long time ago, they would say, Travis started a title company, and he'd say, hey, Miss Linda, if you send all of your agents to us and you end up, all of them refer business, we will take care of them in their education. We'll pay for their continuing ed, we'll take care of all that. You just refer them to us and all their clients come to us. Can't do that anymore, okay? They have to do it without conditions. There cannot be conditions. A title company cannot defray expenses that a real estate agent would otherwise incur, and a title company may advertise and provide continuing education for real estate agents, but they have to actually be paid for it. They cannot simply come up here and say, okay, guys and gals, I'm a title company and I'm offering free education to you. Y'all actually have to pay for them. If not, they're violating this rule and they lose their license. Okay, so some of you agents that I've talked to, some of you have went to the recent one we had, and you had to pay $10. It's not because they were just being cheapskates, it's they can't do that. And if they do, they can lose their license. Does that make sense? Okay. And let me tell you, now I will say this. Oftentimes, title companies, now it's got to be at market rates, but it does not have to be the highest. So oftentimes, they are sometimes the cheapest of the batch. Does that make sense? So they're not going to be competitive with the like, you go to a school, you're not going to pay $200 for an hour, okay? You may pay $10, $15, $20, but again, that's some of those benefits that you get there. Now, in regards to closing statements, Miss Linda, what is debit and credit?
Debit is a debt, and a credit is something that you get.
So a debit, if I have $100 and I debit $100, or well, I have $100 and I debit $10, how much do I have, Mr. Eugene? How much?
How much?
I have $100 and Linda debited $10.
So you got $90 left.
Why not 110?
Because it takes away. It's called
It takes away. It's a debit. That's right. It's a charge, so it's an amount one party owes. Now, if Miss Linda debited $10 from my account and Travis credits me $10, now how much do I have?
You have 100.
No, I had 100. Linda debited $10 and Travis credited me $10.
Back at your 90.
No, I'm back at 100
I mean, 100.
because Linda took away 10
And he
and
put
Travis
10 back.
gave me 10 back.
That's nice.
Yeah, he does that, by the way. If you need money, Travis will just credit you money. But if you know Miss Linda, she debits you. You can ask Travis that too. So, how many debits has she taken out of you?
Quite a bit.
Quite a bit.
And if you're looking for money, none of my cards work.
It's because Miss Linda took it all, right?
Money.
Yeah, Mr. Travis would lend all y'all money, but Miss Linda's already debited it all, so there's none left. So, yeah, every time you put $100 in, what happens to
It
it?
just disappears. Just disappears.
Eugene, have you been having that problem too?
It's been going on for years.
For years too?
You better watch out.
So in that situation is a debit is a charge and it's an amount one party owes. And a credit is, of course, the amount one party basically gets. So if the seller is prepaid an item, he gets a credit for that. Okay? So that's kind of the difference you need to know. So what is it and who pays it? Well, I'm going to test you and I'm going to test y'all real quick. Okay, Mr. Eugene, who pays the broker's commission?
The seller.
The seller. And what is broker commission? What's that for?
For selling the house.
For selling the house. Miss Linda, what's attorney's fees?
Attorney's fee is for
What are they doing? What services are they doing?
checking out things for you.
And drafting documents.
Yeah.
So who pays for that?
Usually oh my gosh, I'm gonna say the buyer.
Depends.
Oh, depends.
Depends. Let's try to spell out depends.
That confused me.
Mr. Stahl, what is recording expenses?
Come on, Travis. You can do it.
Well, after those documents are prepared by the attorneys, does that deed need to be sent somewhere?
Yeah.
And where's it need to go to, most likely? It needs to go to the county clerk. And the county clerk, do they work for free? Does government work for free?
They need to.
They need to, but they don't.
No.
Okay? So it's recording expenses, and that's oftentimes going to be paid mostly by the buyer. Okay? What about title expenses? Who's going to pay title expenses, Stephen?
That would be.
Be careful there. Think about it. Could be who?
It could be either.
It could be either. It could be both. Whenever it checks, it says seller or buyer. Okay, so it could be both. It could be split. There's many different things. But it basically pays for the title. And loan fees, of course, now who's going to pay the loan fees? Common sense, the buyer. Okay. What about, Mr. Eugene, the tax and insurance reserves?
That's gonna be the buyer.
No, it's going to be both.
Oh, both.
Because what happens is it's prorated, remember?
Yeah.
Depending
tax.
Now, of course, the buyer's going to pay it at the end,
Right.
but it's prorated. Appraisal fees, Mr. Grossman, appraisal fees.
No, the buyer.
The buyer. Mr. Stahl, the settlement and closing fees. Could be who? It depends. Depends. Could be both. Survey fees. That's another one, Mr. Stahl. Depends. What about the buyer's earnest money? That's a hard one.
That's a hard one.
That's a hard one.
I say, God, I don't know.
Who pays the buyer's earnest money?
The broker.
The broker
broker,
does.
yeah.
It's just me.
Yeah.
It's
No, it's
just
the
me.
office manager.
Oh,
The office manager pays them.
Miss Leela, help me here.
No, Miss Leela agrees with me.
No, she don't.
yeah, she does. Buddy, you're on your own.
I think I'll go with everyone to give me some money the fastest.
Miss Leela, I thought I was your friend.
No, but you know, I'm afraid of you, Miss Linda. I'm afraid of you. So we'll go with her.
I hear that a lot, Miss Leela.
And of course, the last one, other fees. I mean, it depends. Most of these, you'll see this when you start practicing in real estate. Majority of these guys and gals, it's really depending. Depends on what it is. Because Mr. Eugene, you may come in and say, you know what? I'll pick up the survey and the appraisal. Or I may pick up this. I mean, it really comes down to who? The parties. It's what the parties come to an agreement. Okay. That's why I always tell people when they ask, can I do this? I'm like, well, technically, yeah, if the other person agrees. Okay. It really comes down to that. Now, there is also in prorating, there is the accrued versus the prepaid items. Now, prepaid, of course, we understand that's basic stuff. You paid in advance. So if you paid your appraisal, that's paid in advance or prepaid. Accrued is you did the inspection, you haven't paid them yet, so you increased that or you added that. Those are your differences. Again, rules for prorating. We've talked about prorating before. Remember, prorating is basically you prorate through the day of closing, okay? And the seller pays the expenses and gets income on the day of closing. Now, on a statutory year, these are 30 days months or 360 days. Versus the calendar year, there's going to be the full days of 365. But again, you got to, when you're reading through your contract, you're reading through your hypothetical, you got to make certain guys and gals that you understand these differences. Does that make sense? Because they may say they're in a statutory year. And if they're in a statutory year, that's how many days in a month, Mr. Eugene? Right there, 30 days. If it is in a calendar year, how many days is it? There's 365, and here's the problem. You got to actually remember how many days are in each month if you're going off calendar year. Now, let me tell you, which one do you think Trick's going to do on the questioning? Are they going to make it easy and give you a 30-day calendar, or are they going to make you figure out your days? They're going to want that calendar. Why do they do that? Because if I start going through and I say, okay, Travis, right now, in the days of March, how many days are in there? I need to know right now, right now.
31.
Okay, how many of them the days of September?
31.
How many in March? I mean, April? See where I'm coming into this? But you see, where a lot of times is if you get one of those screwed up, what happens to the rest of them?
Y'all
It's all messed up. They want to do that. They want to trick you. Okay. Again, we've talked about this before. We talked about this before about steps of prorating. Again, it's to calculate the monthly and daily amounts as well as computing time. Multiply the monthly by the daily charge by the time. So you take the monthly amount, divide it by how many ever, multiply it by the daily charge, and you get your normal prorated amount. Again, the ones that are often prorated, we've talked about this before, is taxes, interest, rent, and security deposits. However, security deposits are never what? They're never prorated. Okay. However, it's still due because the fact is that person's assuming that house so they get that money. You cannot prorate it. The arithmetics of prorating is that the annual real estate taxes amount to about $1,800. It's payable in arrears. And what's that mean, Miss Linda, when we talk about arrears? Arrears means what?
Back up.
Paid for the previous. You're not paying for your taxes for 2021. You're paying your taxes for 2020.
Right.
Okay, you're not paying. So arrears means in the past, not in the future. If the closing is set for June 15th, what amount will be credited to the buyer and debited to the seller? Now, guess what here, guys and gals? What's one thing that they have not given us in this question? Look at the bottom two.
The calendar.
They didn't tell you if it's statutory or if it's calendar. So in that situation, guess what that means you get to do? A lot of students says, well, then I'll just get it wrong and I get credit. Nope. It means you got to calculate it off of both, and see which one is on the deal because one of them won't be on there. So you got to calculate it in both the statutory and one as the calendar, and that's going to give you the one that's going to give you the right answer. So you got to do them in both to calculate. Now the hope is when you do it the first time that which one's going to show up. The statutory is going to be there. But now I've had students ask me this before. They said, well, Mr. Noble's got a question. I went in and I did the statutory and I did the calendar and both of them were on there. Well, that's a judgment call. That's a judgment call. That's something that you got to pick on your own because they do not always tell you exactly. Okay.
They will tell you.
And most of the time, but I'm saying,
Like in
yours-
my test, like I never had a question that was ambiguous.
so
They
there
would
you go.
have ones that they would try to trick you, like it would say they would put one or the other one, but I never really got one that was to a point where I was like, it could be one of these three answers, and I have no idea which one. There were some that were tricky, but I could usually get to an answer
To where you were going.
Yeah.
I will say that when I took my real estate agent's exam, it was pretty spot on. But when I took my broker's exam,
Yeah.
because when you're a broker, you have to deal with so many different types of hypotheticals and things and all that crap. And they want you to be critically thinking. So again, you just want to kind of go through these and kind of make your decisions. All right, now, what we're going to do is that basically ends our last slide. That's it. So don't, Mr. Eugene, don't cry. It's okay. It's all right. We're going to get through this together. Okay. So in this situation, we have finished our last slide. And so what I recommend you do is please, if you did not understand this, please go through, listen to it, or read the text. Or if you need clarification, always feel free to email me. I don't mind answering any questions to that nature. But what we're going to do is, Stephanie, if you don't mind, go ahead and let's stop our recording.